and last event for this semester. It has been a unusual semester to say the least, but I think we've had three good events, and I think it's the model that we have used has worked fairly well. So hopefully next semester we will have more. We will have a center meeting very early on in January, and I hope as many members propose events and all of that, and I'll be in touch with all of you in due course about proposing events and so on. And also a very warm welcome to others who are friends of the center who have also joined today. We have a really exciting, I think, two books to discuss. The first will be Elliot, Dr. Elliot Bulmer of Dundee. Until recently, Elliot was working at International IDEA and did a lot of work all around the world in constitution building, advisory work. That did some very useful work, and I have also had an opportunity to work with him in that capacity. But Elliot has returned to academia this year and to Dundee, close to us, and very much hope that he will continue to have a close association with us here in Edinburgh, as he did when he was in IDEA. Likewise, Brian Jones, who has moved from Dundee to Sheffield again quite recently. And Brian brought out a wonderful book with Edward Elgar on constitutional idolatry. And I think for a lot of us who work in the world of written constitutions and using written constitutions of democratization and conflict resolution, Brian's work, even though focused on the codification of the British Constitution, the UK Constitution, is nonetheless very much framed from a very comparative point of view. So it offers a lot of sort of general lessons as well about thinking about having generally a skeptical attitude to what it is that written constitutions actually can achieve. And there's been the sort of recognition, I think, in the practice world after 20, 30 years of this sort of post-Cold War constitution building for democratization, that sometimes we have overloaded expectations of what constitution makings and written constitutions can achieve. So in that sense, I found the book to be a fascinating asking of these awkward and difficult questions. And I'm not going to say too much about that. I'll let Brian speak for himself. So the idea generally is that we will have 20 minutes for each speaker. Elliot will go first, talk about his book, and then we have Brian, and then we will just open it up for questions. And as usual, and as Christina said, and for those of you who may have joined a little bit later, we will be recording the first half, the two presentations, but we will not be recording the questions and answers. And hopefully we will have the recording available in an edited form later on for those who have not been able to join us today. As usual, we'll just keep this very informal. Just raise your hand or send a message on the chat function if you want to ask a question at the end. And in case if I miss it, hopefully Christina will pick it up. But just feel free to nag me if I have ignored you consistently. So without further ado, I would like to invite Elliot to talk to us a little bit about his book. 20 minutes, Elliot.
Okay, thank you very much, Saga. Good to be here. So the book is this one. If you've not seen the cover, Westminster and the World, Commonwealth and Comparative Insights for Constitutional Reform. And there's a story behind every book, right? So every book comes out of an experience, I think. And the experience behind this book was I was working for UNDP in a small island in the South Pacific. My hotel was on Victoria Parade. which is just near Queen Elizabeth Drive, not far from Gladstone Road or Thurston Street, not just around the corner from Gordon Street and Albert Park and Duncan Road. And at the heart of that town was this immediately recognizable Westminster style parliament, where you could have gone into the public gallery and watched the Prime Minister and the leader of the opposition confront each other across the table in front of a ceremonial mace that had been gifted to the island by Queen Victoria in 1874. Right next to that parliament is a cricket ground. And in the middle of the Oval, in anticipation of a visit from a member of the British royal family, a dais and stage had been set up. I read about this in the newspapers. And I spoke to people about it because English is the official language there, even though you can hear all sorts of languages from across the South Seas and the Indian subcontinent. I wanted to go to the university bookshop. That was one of the reasons why I was staying there. And on my drive from the hotel to the bookshop, I passed Holy Trinity Anglican Cathedral, the offices of the Social Democratic Liberal Party, the Trade Union Congress office, even the Masjid Noor Mosque. Basically, all the stuff of a kind of vibrant civic and social life that had been shaped by the laws and the assumptions and the experiences of British imperialism. In the Botanic Gardens, there's a clock tower commemorating the city's first mayor who died in Canada. And when I go to pay the taxi driver, I notice that the Queen's head is still on some of the coins. And this is weird because this country has been fully independent for 50 years and it's been a republic for nearly half that time. And it's come through a turbulent period of inter-ethnic violence and military coups, and now has a constitutional order in place that seems to be working, right? It is far from perfect because all constitutions are far from perfect. And I think it would be idolatry to see them in any other way. But it's got lots of things that are on there that are part of the Charter 88 agenda, right? Part of the reformers' wish list for a UK constitution. It's got proportional representation. It's got judicially enforced fundamental rights. It's got the codification of parliamentary conventions into written constitutional law. So I go over and I have a great curry lunch, as good as any you'd find in Britain at least. And I'm driving along the leafy road that separates the Parliament buildings from the cricket ground is called Constitution Avenue. And it becomes clear to me, that the British Constitution, the British constitutional tradition is far wider, far bigger than really what happens in these islands. There are lots of islands all over the world where the British constitutional tradition took root and developed, and those islands, or those countries, formed a kind of community of similar institutions, similar laws, similar practices, which all have derived from their British antecedent. David Cameron, when he went to Jamaica in 2015, spoke to both houses of Parliament in Jamaica, and he said to them, "This place feels instantly familiar. The benches, the mace in front of us, the atmosphere." He said, "There's much about this place that reminds us of home." And that's true, right? That you can see these patterns and institutions, all with their own distinct flavor, their own distinct evolution, their own distinct fitting to circumstance, but nevertheless as part of a community of constitutions that are part of one constitutional tradition that I call the Westminster model tradition. And the strange thing about this tradition is that in most of these cases, there is in fact a written constitution. There is a supreme and fundamental law that sets out the basic structures and institutions of the state, the rights and responsibilities of citizens, the foundations and principles of governance, that is harder to change than ordinary law. And again, I don't think it is helpful to be too metaphysical about our understanding of what a constitution is, because there is then again, this danger, which I hope that Brian will speak to shortly, about falling into an idolatry of that. Let's be pragmatic and realistic about what we mean here. I simply mean that the foundations and the fundamentals are placed a little way beyond the reach of ordinary parliamentary majorities, so that there is a distinction between the ordinary policy making that depends upon an elected government and its manifesto commitments and its electoral mandate, and changing the fundamentals of the constitutional order, for which some sort of wider process of agreement is necessary. And you find these all over Westminster model constitutions. And in fact, those that don't have it are very much the exception. The UK and New Zealand, everywhere else you find this. And so it seemed to me that, in a sense, written constitutions are as British as a Bangladeshi and a Sri Lankan meeting in an Irish bar in London, Ontario, to watch the West Indies play South Africa at cricket while eating haggis pakoras. You can't get more British than a written constitution. It is the fulfillment, in a sense, of a constitutional tradition which develops, let's say, from the middle of the 19th century into the middle of the 20th century. The starting and ending places are a little arbitrary, but you could look at something like the British North America Act, which was the foundation of the Canadian Constitution, through to something like the Constitution of Tuvalu, adopted in 1978, as the kind of boundary markers of the development of this tradition, which is fascinating because I don't want to get into a discussion around the rights and wrongs of imperialism, only to note that the British Constitution developed in an imperial context. And the heyday of empire was also the heyday of the democratic development of these British institutions, i.e. the late imperial period in the middle of the 20th century. So the book is a reflection on this idea of the British Constitution being wider and deeper than merely an insular tradition. But it is also written in a particular political context, which is, it's written after the Brexit vote, in a context where British institutions seem to have lost what moral authority and institutional clarity they may have possessed before Brexit sort of rips the plaster off. Now, I argue in the book that you could have made it's not a case I particularly advocate or accept, but you could have made a coherent argument in favor of the institutions of the British state in their pre-1997 form. There was a certain logic to it, a certain clarity to it. The Blair-Brown reforms have muddled that constitutional order without settling it upon a new one. That's not a novel argument of mine. That's something that many have said. But I think that it makes this reflection on, well, what is the British constitutional tradition more pertinent? Because we're dealing now with what Peter Hennessy and Andrew Blick have described as a molten constitution, where the unwritten conventions, the unwritten rules, no longer perhaps have the force that they did. And there are many examples in the book taken from the period after the Brexit vote, where we look at how conventions have been violated and political actors have started to play constitutional hardball, and really straining that unwritten system to breaking point. So all I've done in the book is really to try and put those two things together and say, okay, given that there is this wider Westminster model tradition, what would it look like to take that and feed it back into British political circumstances? Imagine that Britain itself were becoming independent from the British Empire, which is another side issue, but it's something that I think desperately needs to be done, right? This idea of understanding that the UK, which was a state founded by and for empire, is no longer an imperial power and needs to adjust to that reality. And maybe Brexit will be a a suitably chastening moment when the realities of that will come home. But even so, maybe something can be salvaged from the wreckage, right? Maybe there's something there where we can look back and say, well, countries that have had this institutional tradition, countries that have valued the kind of parliamentary institutions that developed initially in Britain, have had written constitutions, and they've solved their problems by codifying in a particular way, not as an abstract exercise, not as some sort of misfiring of French revolutionary radicalism, as many detractors of written constitutions would like to portray the process, but really as an attempt to express, solidify, and reaffirm while adapting inherited institutions. And this brings me really to the next part of my argument, and I think the other side of the book, which I think is relatively novel, which is Guardian reading sandal wearers of the liberal persuasion, and I'm using that term, in inverted commas, have long advocated constitutional reform. There's a certain segment of the British centre and British centre left which has been pushing for constitutional reform for a long time, while the right, the centre right, has traditionally been wary of this. I think I would like to argue that actually any constitution that works, any constitution that is stable and acceptable and reflects a broad compromise, has to be based on multi-party agreement. There has to be some coming together. Constitutions that are simply a radical agenda written into legal form, again, as Brian said in his book. And in order to reach that agreement, what I've tried to do here is to argue that there is a Burkean case for written constitutions, a Burkean case for a particular type of written constitution, a Westminster model constitution, a relatively parsimonious, prosaic, pragmatic type of constitutionalism. Perhaps a little less full of abstract theory and rhetoric, and a little bit more full of just, well, let's write down the essentials so that we know what they are. And so that when we have discussions around things like, well, can the Queen refuse assent to an act of Parliament on the advice of ministers? How do two conventions resolve themselves there? We can look back into these written constitutions. We can discern how that's done. We can take things that are tried and tested, and actually the politics are quite difficult, but the legal technical exercise of writing down a codified constitution becomes much simpler if we have embraced this study of the other Westminster model constitutions. So that's what I'm trying to achieve in the book, is firstly to recognize the breadth of the Westminster model, and that that it's more than just an insular tradition. Secondly, to recognize the state of peril that the current British Constitution is in. Thirdly, to bring those two things together and to show that a written constitution is practicable and feasible in a British context. And fourthly, to argue that can actually be expressed in terms that are comfortable, acceptable to the moderate centre right, to Burkean conservatives, who may be dismayed and disgusted by the way in which recent governments have tried to play fast and loose with an unwritten constitution. Because when the good chaps theory doesn't work, you need something else. When people start breaking the unwritten rules, you need to write those down, if only so you don't forget them. Now, I'm running out of time. There is a chapter of the book that deals with objections to a written constitution, including the objection of excessive judicialization, and including the objection of inability to change in the future. On those 2 points, I would say in terms of the judicialization, we can raise it in perhaps more in discussion, but I don't see a written constitution as a rejection of political constitutionalism. judges do have a role to play in enforcing a written constitution, but people also have a role to play, and politicians also have a role to play, both in enforcing it and in amending it, right? So rather than having decisions about fundamental institutions being made by a small number of ministers and civil servants and rammed through parliament on a simple majority, if you're concerned about political constitutionalism and the value of democratic deliberation, then having additional hurdles that require deeper deliberation for certain types of fundamental change is actually a positive, right? And on the point of view of how do constitutions change, and are you pre-committing now to decisions in the future? Again, I would look at a sort of Burkean approach and see that these things, that the state is an association between the living, the dead, and those still to come. That we do not start each generation with a blank slate. That there are things in our tradition and in our inheritance that are valuable and need to be preserved. And therefore, there's a contradiction at the heart of constitutional conservatism between its Burkean desire to preserve and its Habib defense of parliamentary sovereignty. And I argue that you can't square that. If you're concerned with preserving our historical institutions, and if you think that future generations may not rise to this, or at least future governing
Has it completely disappeared, Christina?
No, I think Elliot has returned. He's down at the bottom.
Hi.
Hi.
I was just in my flow. What was the last bit you heard?
The two things can't be squared.
Yeah, they can't be squared, and so some choice has to be made, and that maybe if you want to preserve the principles of Westminster model democracy as they have come down to us, then to entrench them into some sort of constitutional document may well be actually quite appealing to as I say, those sorts of centre-right conservatives who are not impressed by the recent constitutional hardball. So that is my time up. Thank you for that.
Well, thank you very much, Elliot. That was quite a comprehensive sort of, to use a conservative constitutionalism term, an intimation of what your book was all about. Thanks for that. I'm sure there'll be many questions for you later. But I now invite Brian Christopher Jones to talk about his book.
All right, thank you so much for the invitation. It's really an honor to be here, and also to Elliot for joining. Your book sounds fascinating. I haven't given a proper read yet, but I definitely will very soon, hopefully over the holidays. Asanga, when you first kind of emailed about me talking at this event, I kind of thought back to about 5 years ago when I first talked to the Constitutional Law Discussion Group, and I just thought, you know, my God, how much things have changed since then. And when I first talked to you guys, you know, I was writing about kind of the 800th anniversary of Magna Carta, and I was pushing back a little bit against that. And then also I was writing about the Tea Party in the United States and how, you know, they had kind of been kind of the epitome of constitutional idolatry. And then also I wrote a little bit about kind of the interpretation of the Constitution and, you know, how there's always this kind of harken back to kind of the founders and how they would have thought, what they thought about the Constitution. And so I think Brexit and Trump really kind of moved the goalposts of my project quite significantly. So I think even even just kind of more widely, I think there was, after Brexit and Trump, there was kind of a wider kind of interest in constitutions and the inherent value of constitutions. And so some, people have argued that Brexit wouldn't have potentially happened or would have been much more difficult with a written constitution in place. Whereas, with Trump, it was, would a constitution constrain him, right? Or would the constitution even survive, the Trump presidency? But of course, there's kind of some wider claims about written constitutions that are made in the literature. And I think I really love the quote by Gunther Frankenberg, who says that these documents are often enshrouded by an aura of magic. And I would essentially agree with that statement. So some of the claims that people have made in regards to written constitutions are that they would bring the government and the governed closer together, that they could strengthen public confidence and trust in the political system by educating citizens, that they may strengthen citizenship, that they may produce stronger citizen constitutional attachment, that they may produce a longer constitutional lifespan, that they can be inspirational, that they can generate emotions such as love and admiration among its own people and beyond, among current and future generations, and not that they just can impact societies and kind of structure the state, but they can also be transformative on a given state. So in my book, I define constitutional idolatry as drastically or persistently overselling the importance and effects of written constitutions. And I think we've done this, quite a lot in the literature. But in short, I believe that written constitutions have become the false gods of the legal and political realm, and that for all the problems that democracies face, if they are part of the solution, then they are probably only a small part. So there's some internal and external dimensions to the work that I kind of look at in the book. And I think internally, we have this, of course, consistent and kind of never-ending debate over whether the UK should draft a single written constitution. In some cases, I think we see really thoughtful analyses about, what a codified constitution could bring. And I would definitely classify Elliot's book within that. But in other cases, we see, practically anything that happens with the UK Constitution or with politics that kind of, breaks down. We see this kind of knee-jerk reaction for people to go, yep, this is why we need a written document. And of course, Brexit, brought this about in spades, right? You had a lot of potential political breakdowns. And so there was a lot of kind of increased calls for a constitutional document. But there's also some other internal debates that I wanted to dip into as well. In regards to kind of the UK Constitution being, ancient and evolutionary, and that if we had kind of a more modern settlement, then we would have a written constitution. Well, I would push back against that a bit. So the 1688 revolution is the basis of the UK constitutional settlement. And also it's not just the basis of the settlement, it's that, it explicitly rejected codification and entrenchment, right? So written constitution had been tried in England and they failed, right? So the instrument of government, the humble petition and advice, they were not successful. And indeed, by many accounts, they were disastrous, right? So the 1688 revolution said, we're going to draft the Bill of Rights 1689, but we're not going to put forward an entrenched constitutional document, right? So additionally, some arguments put forward in Britain that people, because we don't have a written constitution that explicitly mentions the people, that the people have somehow been forgotten about or left out of the constitutional settlement. And my reaction to that is, so what, right? So Edmund Morgan, in his, excellent book, Inventing the People, has shown that, this idea of the people being integral to, popular sovereignty has largely been a myth, both in the UK situation and in the United States, right? And James Madison, of course, who boasted about the fact that the people in their collective capacity had no share of the US Constitution, right? It was something that he was quite proud about. But the idea of we the people, of course, didn't first arise in the US Constitution or even in the French Revolution of 1789, right? So we saw the idea of, the people, or we the people, in the English Civil War. We saw it also in the Glorious Revolution. You can also go back to the Declaration of Arbroath, where it was present there as well. And so we've seen these ideas before, right? Before these kind of major constitutional documents arise, right? And the UK has just never felt the need to write this down. So this has led some scholars to say that being under a written constitution is more democratic than living under an unwritten constitution. The idea that, we the people constitution or constitutional supremacy is more democratic than parliamentary supremacy has been taken on by many advocates of written constitutionalism, I believe. Dare I say some of those advocates of we the people being grounded in a formal document are really highly suspect of giving the people any increased powers at all, right? And I would say that another aspect of this is that advocates of written constitutionalism in the UK say that it is only the elites that understand how the Constitution operates, right? And that a lack of writtenness or codification may mean that regular citizens don't understand how the Constitution operates, right? So only MPs, only judges, only civil servants in Whitehall, these people understand the Constitution, but the general public doesn't, right? I think there's really little evidence that that's the case. So I present in the book evidence that UK citizens are just as knowledgeable of civic understanding as they are of other citizens throughout the world, right? So there's no drop off in the UK compared to civic understanding as compared with citizens that live under a written constitution, right? And this is also true for places like New Zealand as well. There's no drop off there either. Another thing about kind of the internal debate is some of the objections, are quite common. Time, we just don't have the time or resources. Cost, take too long. Potentially there would be, too much cost involved in drafting a document. Polarization is another one, right? That we could never agree on what would go into a document right now. But I wanted to present kind of a larger and a more principled stance that often really fails to get recognized. And I think that is that, written constitutions may not bring about the claims made by written constitutionalists, right? And that beyond that, they also bring some distinct and unfortunate downsides as well. So those are some of the internal debates that I wanted to kind of touch on in the book. And then also there were some external issues, right? So I think the majority kind of view externally is that essentially, there's only one way to skin a cat, right? You have to have, constitutional supremacy, you have to have a written document, you have to have a Supreme Court basically enforcing that document and being the so-called guardians of that constitutional order, right? And what my book says is, no, there's more than one way to skin a cat, and we've seen it, right? This is what, the UK has shown, this is what New Zealand has shown, and Israel as well, is that there is more than one way to skin a cat, right? And I understand, as Sandy Levinson has said, is that, any criticism of, constitutions or constitutional law is essentially swimming against the tide, and I absolutely agree with that, right? And I don't expect, a lot of people to get on with the arguments that I put forward in the book. But I think it's important to ask some of the questions that I've asked in the book. So some of the book's major arguments are first, that constitutional idolatry devalues politics and the political process. And it intentionally does this, right? So as Jutta Limbach said close to 2 decades ago, the supremacy of the Constitution means the lower ranking of statute, and that at the same time implies the lower ranking of the legislature, right? So this lowers the status of the closest connection to the people, the people's representatives, right? So this kind of, implies that the political realm is subservient to the constitutional realm, which I think really distorts things, right? I don't think you can easily disentangle the political realm from the constitutional realm, right? Secondly, that constitutional idolatry is overly paternalistic, right? It makes us think that most answers can be found in the Constitution or through a particular reading of the Constitution. I don't think this is how answers are usually found, right? But under this system, the answers are usually found through a small cadre of judges, right? And some of those judiciaries have not only said, that the answers can only be found within, but that they're the ultimate guardians of the Constitution, right? As opposed to some other branches, right? Such as the executive or the legislature, or even, the people being the ultimate constitutional guardians. So I'm not so sure that those bold declarations are really helpful for constitutional democracies, to be honest. And constitutional idolatry stifles constitutional maintenance. So I take this on in a chapter. And I think that, this is the old flexibility versus rigidity argument. And I think the UK Constitution has, survived because of its flexibility, right? And I lay out, a number of things that have changed significantly since the 1688 revolution. But I'd like to say as well that in some states now, it's simply not possible to amend the Constitution at all, right? And I really think it's deeply undemocratic for a generation not to be able to amend their constitution in any manner whatsoever, right? But not only that, I think written constitutions have entrenched, really significant mistakes as well. And that entrenchment has made it even more difficult to get rid of those mistakes, right? Some of the other things that the book talks about, so I think that, written constitutions sometimes conceal rather than celebrate some of the most important things within a constitutional settlement, right? So the language of constitutions is, of course, kind of all about constituent power, right? And this celebration of, we the people. But really, how is this power delivered, right? So for those constitutions that supposedly ground the people into the Constitution, there's no added powers that the people get, right, in relation to the functionality of that Constitution, right? The most significant powers that they still have is the vote, right? The vote at referendums, the vote during general elections, right? And also, constitutions often have really little to say about the importance of courts, especially at the beginning of these documents. And this includes some of the awesome powers of constitutional courts, right? So, you have to read sometimes quite far down into these documents to find these really, awesome powers of constitutional courts. So in Germany, this is found in Article 92. In Japan, this is found in Article 76. In South Korea, this is mentioned in Article 111. In Taiwan's constitution, this is mentioned in Article 171. And you may come back with, right, that sometimes this is mentioned earlier, right? So we have supremacy clauses, right? So the South African Constitution says that in chapter 1.2, it mentions the supremacy of the Constitution, right? And that laws inconsistent with this are invalid, right? So you may say, oh no, it mentions it earlier. It doesn't have anything to say about how that's enforced, right? It doesn't say that the Constitutional Court is going to be the ultimate decider of what's constitutional and what isn't, right? Because that's not the language of constitutions. The language of constitutions is focused on the people, right? So it's, not surprising that in 2016, when there was a constitutional knowledge test in South Africa, that not even half of those surveyed knew about the power of the Constitutional Court to strike down laws passed by Parliament, right? If the law goes against the Constitution, only 48% answered this accurately. And I mean, we can talk about this in the Q&A, why do constitutions not mention this early on, right? I have no idea, your guess is as good as mine. I mean, if I was to speculate, I'd say that, as I said earlier, the language of constitutions is about the people, right? It's not about courts or constitutional courts or how they're going to, guard the Constitution, right? And if this language in regards to courts was kind of front and center, maybe people, wouldn't support constitutions as much as they do, right? I don't know. That's purely speculation, but we can talk about that in the Q&A. The book also talks about kind of this tenuous connection between good constitutions and state success, right? So we have a lot of examples, I think, of what wouldn't be classified as necessarily good constitutions. I think they'd be classified as kind of deficient constitutions, maybe. So some of these are kind of the imposed constitutions, right? So the German Basic Law, right? Written for West Germany, written heavily influenced essentially by outsiders, was never voted on by the German people, succeeded, still doing quite well, a lot of people would say, right? The Japanese constitution, again, written by outsiders, imposed, although David Law may take issue with that, but still, in force, hasn't been amended, which I think is, fascinating. But the country has been, doing quite well generally, right? Taiwan's 1947 constitution, essentially written for the whole of China, right? Written for a completely different country, still contains some, really awkward provisions as regards to kind of the one China principle. And yet Taiwan's thriving, right? It's, it has recently dubbed the new bastion of free speech in Asia by the New York Times. It's got a strong commitment to civil and political rights, strong economy as well. So, I think this really kind of shows that, good constitutions or maybe even kind of deficient constitutions is kind of highly questionable, right? And what do we mean when we kind of talk about constitutional success or failure? I think in the literature, there's kind of a feeling that constitutional cleverness, right, and drafting will get you there, right, to get you to this kind of decent constitution, right? So Stephen Luke's, in his fictional novel, has this great quote, right? In his novel, The Curious Enlightenment of Professor Karatat, he says, "It may sound difficult, but the problem of setting up a state can be solved by a nation of devils, as long as they possess understanding," right? It's just, I think, a brilliant line. And you kind of see this in the constitutional literature as well, right? So Hardin notes that a degree of constitutional cleverness can both facilitate state operation and block harmful behavior. And yet, the UK and New Zealand, and even to a certain extent, Australia, would be said to have a lack of that cleverness, right? And yet, you see these states, at or near the top of some of these tables when it comes to democracy and human rights indicators, right? So I really would question that idea that, having constitutional cleverness can solve, a lot of these problems that we have. So I have, of course, focused on America to a good deal in the book. And I understand that, there are questions in relation to kind of the comparative nature of kind of too much focus on America. But I think there is some relevant things there in terms of kind of how kind of what I talked about earlier in regards to kind of the aspirational ideas of some of these documents, right? And whether or not it can accomplish, kind of a closer set of governance between, governments and the people, and whether or not we can realize some of these, strong aspirations for constitutions. Because of course, in the US, the written constitution is, adored or idolized by a wide segment of the population. It regularly sits atop bestseller lists, which means there, at least, we can assume that there's wide amount of constitutional engagement with the document. It's also relatively short as well. So, maybe we can expect citizens to understand it a bit more, right? It's maybe easier for citizens to get through. And yet, in most, I think, constitutional knowledge tests, we see a really poor understanding of, constitutional document itself and really the operation of the Constitution in the US when you have these knowledge tests applied to citizens, right? So there's a lot of questions there in terms of, how positive we should be about these documents. I think I'm about to run out of time. Yeah, so I wanted to say a little bit about, so I start off the book with this kind of, the 2016 election campaign, right? And this really kind of dramatic moment at the Democratic National Convention, right? With Khazar Khan, holding up this pocket constitution and asking Donald Trump if he'd ever read it, right? And I think that to me was really significant, right? And I think it showed that there was this real focus on kind of Donald Trump being, a figure that was kind of an unconstitutional figure, right? That he was an unconstitutional nominee. His ideas that he was presenting were unconstitutional. He didn't know anything about the Constitution, right? And there was this kind of over focus for me on the constitutionality of Donald Trump, right? And what ended up happening, he won the election. A lot of his ideas that he was presenting that people said were unconstitutional, essentially, were validated by the Supreme Court. And I think, in hindsight, looking at kind of the 2020 election, I think you didn't have that kind of constitutional idolatry frame anymore, right? So, I think there was a bit more kind of realism about, Donald Trump in terms of his performance, right? And the way that he's handled himself, his competence, right? So Obama talked about him not taking the job seriously. And, there was a lot of criticism of his handling of the pandemic, right? And I think this focus on competence and performance was a much better critique of kind of Donald Trump, and was probably quite good for the Democrats in terms of the electoral fortunes as well. But let me end with this, because I know I'm over time now. I think it's quite easy nowadays, for us to disparage politics and the political process and to say that there are other answers, right? And of course, written constitutions definitely may be one of these answers. But I think that really only gets us so far. Right? I don't think written constitutions are going to give you more engaged or more knowledgeable citizens, right? I don't see it. I don't think that written constitutions are going to provide the people any enhanced role in the state, right? Or at least not the written constitutions that have come about in recent times. I don't think written constitutions are going to help bring about needed constitutional change, right? In fact, they entrench constitutional mistakes, and they make it more difficult to change those. And I don't think that written constitutions are going to give us a healthier politics, right? We have more written constitutions than we've ever had. We have longer and more detailed written constitutions than ever. We have wider enforcement by constitutional courts than ever. And yet the state of our democracies is not great, according to a lot of people, right? And maybe even said to be deteriorating, right? So we're more polarized than ever. Studies show less faith in democracy than ever, and we have less faith in politicians and the political process than ever. So I'm really highly suspect that more writing and more written constitutionalism is the answer. So I think we need to recalculate our expectations of constitutional possibility. Written constitutions may work for some jurisdictions, but I think they're not necessarily the only way forward. And that unwritten constitutions can also prevent a viable path forward. So thanks a lot, and look forward to the questions as well.
Very many thanks, Brian. Really stimulating. Thanks both for two really very interesting presentations. I have no doubt it will generate a lot of questions. We have about 45 minutes, maybe a little bit more if you want to go along. That'll be fine.